Hello, my name is Austin Gilly and my fatherhood is on trial with AI. In this step, Claude reviews the court's first reunification therapist. My oldest daughter was staying up all night at visits holding a knife. Meanwhile, the guardian ad litem saw no reason to end visits and continued requiring them. And Mom went around the kids' attorney and formally requested the court end my visits. On December 21st, the court denied the motion. Claude described the structural problem this way: no one with authority was treating the children's behavior as evidence of anything. The next day, December 22nd, our four children refused to open Christmas presents with my parents and me. On December 24th, in my own quest to understand my children's behavior, I worked through Dr. William Bernet's clinical literature on parental alienation, trying to figure out whether what I was seeing in my children matched a pattern. By the time I finished the document, I had concluded that 5 out of 5 factors were present. Claude described what followed across the next 6 months as one pattern. Reunification therapy was set up, deployed, and failed. Mom unilaterally decided to continue individual counseling with the reunification therapist, who quit, and Claude determined the lack of any clinical notes pointing to any reason for the children's behavior as the most significant finding. During that same time, visits with Dad continued under court order, and the children continued to hide. Legal filings escalated on both sides until both parents were positioning for full custody, and by June, both sides were preparing for a court hearing. During this same period, Claude examined all correspondence through the family app Our Family Wizard. Claude describes the interactions as primarily transactional and asymmetric. Mom announcing decisions, scheduling, and logistics, Dad responding with clarification, procedural questions, or routing to counsel. Substantive co-parenting deliberation about the children's escalating behavior was largely absent across the entire corpus. On the 15th of January, Mom reported on our oldest daughter's schedule for the week that she would be participating in a horse therapy training for school credit at the House of Healing. Claude noted that this as a primary source identification of two things: the horse therapy and equine therapy model my father-in-law had co-authored, and House of Healing, the location where my children were taken when the filing occurred the year before. My oldest daughter was, at 16, receiving school credit through her grandfather's professional work, the same man whose own messages in January 2022 first introduced the theory that the children's difficulty was emotional abuse by me, months before any filing. Claude also reviewed the clinical record, and on January 11th, my son told his pediatrician he was afraid of his dad. The same day, Mom drafted her summary notes that would be provided in discovery that she was a mama bear. The doctor documented his anxiety symptoms and gave him an F41.1, generalized anxiety disorder diagnosis. I share that health information only because it's important, because, as Claude noted, it indicates there was nothing to trigger abuse recovery, PTSD, or a report to Child Protective Services. 12 days later, on January 23rd, the children met with Michael Smith at Pathways Professional Counseling. They met with him for the first time. He was the only therapist the guardian found who accepted my insurance and was available the following month. On February 23rd, Smith met with my oldest daughter and me together. Smith and I disagreed in the session. He framed our differing accounts as, quote, two recollections of the same incident, and I asked him whether he had ever encountered the level of children locking themselves in a bedroom. He said never. He thought the divorce was unfortunate, but that this was a 50-50 custody case in his clinical assessment. Claude described Smith's approach as for an ordinary divorce. His clinical record across the next 2 months would show the same thing: standard behavioral therapy. My oldest daughter commented during the one and only session that, quote, "This is not a normal divorce." The therapist would later admit someone more qualified was needed for this case. After the February 9 hearing, the parties reached a verbal agreement on visitation pending reunification counseling. The order was circulated. On February 15th, opposing counsel emailed, forwarding now to my client for signature. The signed order didn't return for over a week. During that time, I was provided no visitation. On February 23rd, my counsel filed a motion to enforce visitation. The signed agreed order was filed the next day. The visits that resumed showed the same pattern as before. Chairs turned away at Chili's on February 28th, opposite sides of the playground at a lake on March 5th, hiding in the aisles at Academy Sporting Goods store on March 7th. Claude noted that none of it generated specific clinical content in the therapist's ongoing individual session notes. On March 8th, after a court order specifying his role and obligations, Michael Smith resigned as reunification counselor and sent a letter to all attorneys. Claude analyzed the withdrawal letter and determined it was an insult to my counsel wrapped in procedural justifications, not a legitimate critique of the academic framework. The next day, Mom decided to unilaterally make Michael Smith the kids' individual counselor. I objected, but the framework was already being repositioned before the same week ended. By March 15th, Mr. Smith had been redeployed as my oldest daughter's individual counselor, placed in continued clinical contact with the oldest, who Smith himself had said had a recorder app and was building a, quote, narrative from talks with her mother. 2 days later, my counsel sent a letter to opposing counsel. The letter described what Mom was doing in clinical literature terms. Quote, "She is attempting to alienate these children, and such behavior is tantamount to psychological abuse." That phrase, alienation as psychological abuse, was being formally articulated by counsel for the first time in writing. On April 3rd, my counsel filed a dual motion. It was both a response to opposing counsel's motion to suspend my visitation and our own motion to modify child placement, basically to remove the children from their mother and place them with me. The motion deployed the academic literature on parental alienation, William Bernet's 5-factor diagnostic model, Richard Warshak's literature on prevention and remedy, and the American Bar Association study, Child Held Hostage. The motion specifically attacked Michael Smith's continued involvement. Quote, "Petitioner has elected to continue using Michael Smith for therapeutic counseling with the minor children, suggesting an alignment between Mr. Smith and the petitioner." Claude notes the framework was now formally on file. On May 3rd, as I received discovery documents, I prepared a one-page analysis called Evidence of Psychological Abuse to Children by Moms Manipulating Behaviors. It used a single example, lifelong family friends our children had known since birth. In June 2022, weeks after the filing, I attended our friend's baseball game. Mom's contemporaneous handwritten journal entry from that day, obtained later through discovery, said, quote, "We were probably losing those friends and was very sad." 9 months later, in March 2023, Mom would write to me that the children themselves had no interest in continuing that friendship, and she had no clue why. On May 5th, my counsel sent a second letter to opposing counsel. This letter cited the statutory definition of psychological abuse and the federal definition. The phrase moved from, quote, "tantamount to psychological abuse" to now being statutorily grounded. The last visit happened on May 7th. The pattern was the same. On May 9th at 1:41 p.m., Mom sent a message. "I have to pull our oldest and middle daughters from counseling as your unwillingness to pay your portion has made it where I cannot afford it on my own at this time." 43 minutes later, I replied, "It is not an unwillingness to pay, it's waiting for clarification on who is responsible for what." I had been asking who carried the bill for Mr. Smith's individual counseling sessions, given that Mom had unilaterally redeployed him in that role over my objection. Mr. Smith had not seen either daughter since April 26. The clinical records showed no sessions between April 26th and the May 9th announcement. Claude determined that the cessation predated the announcement framing by 13 days, and that Mom's framing flattened my stated position into a refusal to pay that the record did not support. On May 8th, opposing counsel filed a 162-page response motion. It contained 29 numbered exhibits. It deployed every category of substrate that had been compiled. It deployed children's journal accounts compiled by Mom, my son's January 11th medical record, Mom's same-day journal extending the medical record account, my own December 2021 notes from a marital counseling precursor conversation, Mr. Smith's March 8th withdrawal email, my 2022 family letters to friends and relatives, references to a 2008 administrative leave matter from my employment 15 years earlier, text messages between me and the children. It cited literature critiquing the parental alienation framework, and it deployed a framing that would persist. As of May 5th, 2023, the respondent has, quote, elected to cease visitation with the minor children of his own accord. That phrase, unilateral cessation, first appeared here. The motion's prayer for relief asked the court to order me to undergo psychological testing. On May 10th, my counsel made the first contact with Trey Trotter, a licensed marriage and family therapist who would later become the second court-appointed reunification professional. On May 17th, counsel deposed Mom. On May 19th, counsel deposed me. On May 20th, the day after my deposition, I wrote a letter to my children. I had decided I needed to update them on what their father was doing. My move, church, divorce care, counselor, friends, work, 8 months of life they hadn't been a part of. The letter ran 2 pages. It closed, I am still your dad, always will be, and I will always love you no matter what. 2 weeks later, opposing counsel would characterize the letter to my counsel as containing language about destruction of a family and funerals for the family. Language, Powell said, warranted serious counseling for me. Claude determined the letter does not contain a funeral reference. The, quote, destruction language is one phrase. The full sentence is this, quote, I hope this process of destroying our family can end soon, and we can begin building something new for better days ahead. On May 23rd, the Guardian ad litem set out a 4-point plan to address what was happening. Visits resume immediately on the original schedule. Mr. Smith resumed reunification counseling. The 2 younger children begin individual counseling. A meeting between me and the children at her office on June 1st from 2 to 4 p.m. It was the only window before her departure for Europe on June 5th. I responded the same day. I declined to meet with Mr. Smith. I declined the vague visitation terms. I asked that the 2 younger children see counselors at a different facility than Pathways, where Michael Smith was, and I agreed to the June 1st visit. June 1st came, and the meeting did not happen. On June 1st, the same day the meeting did not occur, I drafted another letter to family and friends. I had spent the spring researching what my father-in-law had been part of at a Christian school ministry years earlier, a similar pattern of a separated father, children adopted as wards of substitute parents, a reunification counselor unable to do his work. I had contacted the actual father, verified claims through the county courthouse records, and reached out to the deceased reunification counselor's widow. She described ministry staff at the time as having demigod-like attitudes that ostracized anyone who disagreed with them. The parallels were exact. I drafted a family letter explaining everything, but I did not send it. The next day, opposing counsel responded to my counsel's request to resume visitation. He acknowledged in writing that the guardian ad litem had attended a continuing legal education on parental alienation post-deposition and had assessed my behavior as opposite of what alienation looks like. He committed to defending against the framework any way necessary. He framed me as, quote, gaslighting mom to the kids. And he stated his strategy explicitly, quote, I want our judge to see all of this and decide on the best route moving forward for this family. The psychological abuse framework was now formally engaged on both sides, and both sides were citing a pattern of behavior. On June 5th, the guardian left for Europe. She would not return until July 9th, one day before the temporary orders hearing. On June 6th, Powell's paralegal sent my counsel an offer. Powell, the opposing counsel himself, would host a meeting between me and the children at his office. I responded to my counsel with procedural questions. Could my retained expert zoom into the meetings? Was there any assurance the children would actually talk to me? Did the children want this, or were they being forced? The offer went nowhere. The questions went unanswered. The meeting did not happen. By the end of the first week of June, the lines had been drawn. The flurry of legal filings had compounded into a thicket. My children's behavior was unchanged through the entire reunification arc. Visits had effectively ended on May 7th. Both sides were positioning for full custody, each framing it as protecting the children from the other parent. The first courtroom showdown was 4 weeks away. Would mom and dad cooperate? What would the court decide at the hearing? The guardian ad litem, the court-appointed advocate for our 4 children, insisted across the case that this was a 50-50 custody matter and that visits must continue. When mom filed her petition asking for joint custody, the GAL recommended joint custody. When mom moved to suspend my visits, the GAL recommended against it. When mom moved again, the court denied her again on the GAL's position. The May 23rd 4-point plan drafted by the GAL herself required visits to resume immediately on the original schedule. Her position across the record denied any abuse framework, but she had no answer for why our children were behaving the way they were. She insisted the kids visit me on Father's Day in 2023, but she left for a vacation to Europe and she returned the day before the court hearing. I will leave you with Claude's assessment here, and next we will review what the court does at another hearing.